So this case of Lucy versus Zehmer is one of the classic contract law cases, and it comes to us from the Virginia Supreme Court, and it was decided in the year 1954. And this case is all about the topic of mutual assent. So, what does it mean to have mutual assent in the formation of a contract? So, this story of Lucy versus Zehmer starts in the year circa 1942. And that year, Mr. Zehmer and Mr. Lucy were both looking at this piece of property that went by the name of Ferguson Farm. And I'm going to call it FF for short. So both Mr. Lucy and Mr. Zehmer are looking at this piece of property called Ferguson Farm. Zehmer ends up making an offer for it, and he offers $10,000 around 1942. And the owner of Ferguson Farm ends up taking that offer and sells him the farm. And so around 1942, Mr. Zehmer purchases Ferguson Farm, beats Mr. Lucy to the punch, and buys it for $10,000. Now you can imagine Mr. Lucy's frustration when just 2 years later, around the year 1944, the value of Ferguson Farm had just about doubled and was now worth about $20,000. And so Mr. Lucy, having lost out on the property 2 years earlier, decides to make an offer to Mr. Zehmer to buy Ferguson Farm for $20,000. And Mr. Lucy, when he hears this offer and realizes that he has doubled the price that he paid for it, decides to accept and agrees to sell Ferguson Farm to Mr. Lucy for the amount of $20,000. And Mr. Lucy, very happy about having acquired Ferguson Farm, which he missed out on 2 years earlier, is excited. And when he brings the paperwork to Mr. Zehmer to finalize the deal, Mr. Zehmer decides to renege. And to Mr. Lucy's frustration, he is not able to enforce this deal because it was not in writing. And you'll recall from our introduction to contracts video that being in writing is not an element of a contract. However, there is this thing called the statute of frauds, which requires that some contracts do need to be in writing. And one of the contracts that's required by the statute of frauds to be in writing is a contract for the sale of real property. And so, because of this statute of frauds, around the year 1944, this deal that Mr. Lucy and Mr. Zehmer had made to sell Ferguson Farm for $20,000 falls through. And that leads us to the year 1952. And by the year 1952, the value of Ferguson Farm had more than doubled once again and was now worth about $50,000. So you'll recall, so Ferguson Farm When it was purchased in around the year 1942, it was worth $10,000. By 1944, it was worth about $20,000. And now we get to the year 1952, and it is looking to be worth about $50,000. And Mr. Lucy, looking at this trend for Ferguson Farm, basically doubling in value every few years, is kicking himself for not purchasing it in 1942. He's still brooding over Mr. Zehmer backing out of the deal to sell it in 1944. And now in 1952, it's now worth almost $50,000. And Mr. Lucy decides that he's going to make one more attempt to buy Ferguson Farm from Mr. Zehmer. But this time, Mr. Lucy is determined not to get burned once again by Mr. Zehmer. So the first thing that Mr. Lucy does is he invites Mr. Zehmer to dinner and basically gets him drunk. And so they're both drinking, having a good time. And then Mr. Lucy decides to make his offer to Mr. Zehmer. And he does this in a way to sort of goad Mr. Zehmer's ego. And Mr. Lucy says, "Bet you wouldn't take 50,000 for Ferguson Farm." So Mr. Lucy makes that offer, and you can see that he is sort of stoking Mr. Zehmer's ego, trying to goad him into calling Mr. Lucy's bluff. And Mr. Zehmer ends up taking the bait and says, "I would too. I would too. You don't have $50,000. And Mr. Lucy, determined to not make the same mistake that he made in 1942, tells Mr. Zehmer, "Put it in writing." And so the two of them end up spending this night of revelry drafting a contract on the back of their receipt for dinner and basically agreeing to sell Ferguson Farm for $50,000. And Mr. Lucy tells Mr. Zehmer to sign it. So Mr. Zehmer signs their little makeshift contract. And then, just for good measure, Mr. Lucy also makes Mrs. Zehmer sign it. And then Mr. Lucy also signs. And so this deal now is for $50,000 for Mr. Zehmer to sell Ferguson Farm. So that is the deal that they make, and then they both go home for the evening. And then the next day, Mr. Lucy comes back to Mr. Zehmer with paperwork to close the deal, and Mr. Zehmer replies, "What? I was joking." This time, Mr. Lucy has it in writing and tells Mr. Zehmer, "See you in court." This case ends up going to court, and in court, You have the judge, and I'm going to give him a wig. So you have the judge hearing testimony from Mr. Zehmer, and Mr. Zehmer testifies that when he agreed to sell Ferguson Farm for $50,000, he was he was high as a Georgia pine, as high as a Georgia pine. And this whole thing was just a bunch of two doggone drunks bluffing to see who could talk the biggest and say the most. So this is Mr. Zehmer's defense that he was high as a Georgia pine when he made that deal, and the whole thing was just a bunch of two doggone drunks bluffing to see who could talk the biggest and say the most. And the court actually rules in Mr. Zehmer's favor, but Mr. Lucy ends up appealing, and he appeals all the way up to the Virginia Supreme Court. And so the issue that the Virginia Supreme Court has to answer is whether mutual assent for a contract exists when one party is joking. And when you read the decision of the Virginia Supreme Court, it can be a little bit confusing because they don't believe that he was actually too drunk to have the capacity to assent to this contract. And they also don't really believe that he was joking about the contract. Uh, but they also say that it doesn't matter. They basically hold that mutual assent is judged by the parties of a contract, expression their expression of assent and not unexpressed intentions. And so, what they're basically saying here is that it doesn't matter if one party is secretly joking about entering a contract. They say that when we're judging a contract, that when we're judging this contract, we have to look at the point of view of Mr. Lucy and to think, is Mr. Lucy, did he reasonably believe that Mr. Zehmer was serious? And so the court says that we look at this whole situation from the perspective of Mr. Lucy. Did he actually and reasonably believe that Mr. Zehmer was being serious when he agreed to sell Ferguson Farm for the amount of $50,000? And they look at all of this contract negotiation that the two of them did. the fact that Mr. Zehmer went and got Mrs. Zehmer to sign the deal, the fact that both of them had made edits to the written instrument uh, that negotiated the sale, that all of this showed that Mr. Lucy was justified in believing that Mr. Zehmer was serious. And it was reasonable for him to believe that. And so it doesn't matter if Mr. Zehmer secretly harbored an intention to not be bound by the contract, because he made Mr. Lucy believe that this was a real deal. Mr. Zehmer was going to be bound by the terms of the contract. And so the Virginia Supreme Court orders that Mr. Zehmer perform the contract. And the court orders that Mr. Zehmer basically furnish Ferguson Farm to Mr. Lucy upon payment of the $50,000. And I also make a note that this is the remedy of specific performance. And specific performance is what is known as an equitable remedy. And the equitable remedy of specific performance is not usually awarded for a breach of contract. In other words, the ordinary remedy for a breach of contract is that the losing party pay damages, monetary damages to the winning party. But even though the equitable remedy of specific performance is an extraordinary remedy that is not usually awarded for breach of contract, it is often awarded in these cases of breach of contract for the sale of real property, because the courts recognize that a piece of property is unique, and two pieces of property, even though they have the same value, are not necessarily worth the same amount for an individual. And so, usually, when you make a contract for the sale of real property, the court will order you to make good on that sale and will not just order you to pay damages to the losing party. But in any event, the main takeaway from this case of Lucy v. Zehmer, which I'll go ahead and call the rule of law, is that mutual assent to form a contract is judged by an objective standard and not a subjective standard. And what this means, again, is going back to the holding of Lucy v. Zehmer, that when we are looking at mutual assent, we care about what are the expressed intentions of the parties, and we disregard the unexpressed or secret intentions of the party. And so, if you are a person who is thinking that it would be funny to make another person think that you are entering into a contract when secretly you have no intention of doing so, you should be aware that a court is not going to give you any credit for that secret intention if you make another person think that you are entering a contract with them. Then the court will enforce that contract, even if you didn't actually assent to the contract. And so, this rule of looking at the objective evidence of mutual assent is the reason why Mr. Zehmer lost this case in Lucy v. Zehmer, because he never made any sort of objective expression that this whole thing was a joke. But in that case, let's think about if the situation were slightly different. And let's say that Mr. Lucy has the contract and it is signed by Mr. Zehmer. And then right before Mr. Lucy is about to sign his name on the contract, Mr. Zimmer shouts, "Psych, April Fools." It was all a joke. What would the result of this case be if Mr. Lucy had not yet put his name on the contract and Mr. Zimmer suddenly shouts that this was all a joke and that he actually doesn't have any intention of entering into a contract to sell Ferguson Farm? In that case, now that Mr. Zimmer has made his secret intent to not form a contract known to Mr. Lucy, how might this change in circumstances affect a court's judgment as to whether or not they have an enforceable contract?